Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Zayas presiding, is now in session. Please be seated.
Good morning.
Good morning.
How's everyone doing today? Good. It's a beautiful day out there. All right. So we have 4 cases on today's docket. 2 are scheduled for oral argument this morning. The first case we have that has submitted on the briefs is cases number C2201-04126 in Re BR. The next case we have that is scheduled for oral argument is case number C210366. Now, if I say the names incorrectly, feel free to correct me, okay? Ajikoli versus Alongbi.
All right.
Okay, so sir, you're here to represent yourself?
Yes, I'm a pro se in my case.
Okay, that's fine. And,
Kristen Reeve Summer, Your Honor, for Ms. Adikola.
okay, very good. I'm going to continue to read the docket. The next case is C210472, which is Sharif versus Sharif. If parties could please identify themselves in readiness to proceed.
Good morning, Your Honor, Barbara Arnold, the appellant, for this proceeding.
Good morning.
Amy Keller for the appellate.
Thank you. And the last case we have that also is submitted on the briefs is C210149, State of Ohio versus Devin Gallinari. Okay, so Mr. Ajikoli,
I'm Gabriel along with. You can call me Gabe.
okay, I'll call you Mr. Ajikoli. How's that?
No.
Oh, I've got it confused. You're Mr. Alongbi?
Yes.
Okay, Mr. Alongbi. Let me explain to you. So you have 15 minutes to present to us orally whatever it is that you would like to present with regard to your case and what it is that you'd like to share with us. Of those 15 minutes, you can reserve any portion of it to then respond. So let's say you reserve 5 minutes. That means you will argue for 10 minutes. The attorney for your former spouse will argue for 15 minutes, and then you will argue for 5 minutes, if you were to reserve 5, for example. Okay? So of the 15 minutes, how much would you like to reserve? And you reserve any amount you want.
Can I change my mind as I present?
How about if you reserve a certain amount, and if you decide that you want to keep going, I will let you know, which will then take away from the reserve. Or if you want to end early, whatever you have remaining, I will take it and put it into your reserve.
Okay. And
All right.
I have a summary here to give to you. Can I?
We have everything with regard to the case. All 3 of us have it already. Okay?
I
So
know the trial court did not accept my exhibits, and so.
Okay, well, whatever is proper within the record, we have that, okay?
Okay.
So how much do you want to start off with the idea of reserving? Of reserving, that is.
Let me reserve probably 3 minutes because I have quite a bit of things. I'm
All right.
not sure that the 12 minutes I'll have will not be enough for
Okay.
me to cover this, and that's why.
Okay. Well, then decide what you want to focus on first, and I will give you a heads up as you are getting close to your 12 minutes. Okay?
Okay.
So what you're going to do is you're going to come forward here. All right.
Time begins when. Do I have to introduce
When you're
myself?
ready, that's when time begins,
Okay, so I still have to introduce myself at that time. Okay.
if you like to.
Yeah. My name is. I thank you for the opportunity to be here. My name is Gabriel Alongbe, and I am representing my case in the child custody case. I'm a Nigerian American. Have been here for over 44 years. Went to school here.
Congratulations.
Did all my education. I was a professor at UC. Currently, I am not there. And I want the best for my children, and I have the means. and everything to give them the best in life, and demonstrated by the exhibit. I'm here to obviously that I appeal the decision of the trial court, and essentially what took place there, was against my due process. When the GAL did investigation and wrote his report, by the way, I had submitted a motion for termination of GAL way before he submitted his report, and obviously he took offense to that, and he showed me in his report by writing things adversely against me, even though the evidence I have is not like that. So the only approach for me is to, obviously, for the litigation is for me to prove him wrong, refute what he wrote in there, or to impeach him. Unfortunately, when I requested a file motion to compel him so that he can give me files, documents, and everything that he collected in the course of his investigation, he objected. He objected. I was surprised because, and then it came to court that I was hoping that the judge is going to, you have to give me the documents so that I will have the opportunity to cross-examine him during the hearing. And the judge denied it. So when the judge denied it, I then had to obviously appeal the case, again, essentially for the denial of due process, and also through denial of compel him. When the judge, or when he refused, GAA refused to give me his document, he cited confidentiality, and that GAL and the people that he or she interviewed, whatever thing that was discussed, there is documents exchanged, there is no confidentiality there. There is no. And I did all my research. In fact, the state of Massachusetts, in Massachusetts versus Lamb, and that is LAMB, said that GAL cannot cite confidentiality. In fact, they call it Lamb warning, Lamb, LAMB warning. So before GAL interviews or talk to anybody, he must tell that person that whatever thing that will be discussed is not confidential. Anybody, I have a right to view all the documents, the files, anything that the GAL has, including that of the plaintiff, just like the plaintiff also has a right to view everything through the GAL of what I submitted, and that was not the case. And the judge sided with him. So I felt that my due process actually has been breached. Also, the judge in his decision, he wrote, which is wrong, he wrote that no evidence were offered or admitted into evidence. No exhibits were offered or admitted into evidence. As you can see, those are the exhibits. In fact, it was even bigger because I had it in a 3-ring binder, and it was really big. It's just that it's cumbersome to carry it in 3 rings, so I had to get that thing.
The exhibits were not admitted, right? That you tried to admit them in the judgment.
Exactly. Yes. Several times, and that's on the transcript. So if you go to transcript lines 15 to 23 on page 81, lines 3 to 4, and 19 to 24 on page 101, lines 19 to 20 on page 112, and lines 12 to 14 on page 114. I tried several times, and the judge will not, because there is no way that I can litigate my case without seeing what is in here.
But wasn't the reason why the judge wouldn't let you admit your exhibits is because you didn't disclose your exhibits to the other side until the night before?
No, that is not the case. Okay. That's not the case. They have had it, they have had all my exhibits right from, I think 2017, it was exchanged electronically. I know she just came on board. Well, she was there from the beginning, but she was not the one representing. and another person was representing. No, I submitted it electronically, and honestly, with respect to GAL, those things, as soon as I prepared them, they were sent through my attorney, Attorney King. I used to have Attorney King until the cost just became too much for me. It was sent through Stephen King, forwarded, and I have all the documentation because I used Dropbox to send these things, that document.
Is that on the record? I mean, is that part of the trial court record?
Part of sending through Dropbox?
Yeah, I mean, is that part of the record that we can see if we look at the trial court record? Did you submit any proof of that?
Yeah, that I did that. Yeah, I have, excuse me. I have the proof in here. And another thing again is...
Let me make sure that we're clear. I think are you saying that the exhibits that you were trying to submit that were denied, that they had already been previously submitted through your proceedings?
Exactly. Through my attorney to the GAL.
Okay.
And I just found, in reading his report, the GAL never read anything that I submitted. Over 1,000 pages of documents.
Had the exhibits been turned over to opposing counsel, I think that's the reason why the judge wouldn't let you introduce them, because the judge thought that you dumped 1,000 pages on opposing counsel the night before the trial.
No, that is what they said. I can bring documents that shows that. Like I said, I submitted it electronically through them, and they have this. I can go back way back.
So your argument is they already had all this 1,000 pages. This was
Right. The GAL already had it because the
not
first...
the GAL, the opposing counsel.
Yeah, the first attorney, she is the second person, So she may not be aware or be familiar with all the exhibits prior to her, taking over, But I have those exhibits. Like I said, they allowed us to submit exhibit electronically. Because I know that if I don't give it to them, obviously it's not going to be admitted. And this exhibit has been going through the court for a long time. They know this. It's nothing new. I just add to it. And the exhibit B, volumes 1 and 2, I started writing that to document what was happening to the children. Because obviously I can't keep everything in my head, So that way, I write it, there are 41, I call it situation reports, number 1, 2, 3, all the way to 41. And every time I write it, I submit it to them. I forward it to GAL at that time. And so that's one of the things. And again, So
just to let you know, you have about 4 minutes of your original 12 minutes.
Okay. The GAL said that I attended Autumn's, my children's Zoom online, and the GAL said, no, the teacher said you cannot do that, and that is not true because I have evidence that I still have all the videos. I recorded them. I recorded all my attendance online. And I asked the judge, let me show it in court. The judge didn't want me to show it.
How many hours are we talking about here?
What I did was actually, I kind of condensed it. Obviously, it's way too long, so I have a situation where my daughter was going to school online without, her camera was not working. So that I took about 3 minutes of that, condensed it to 3 minutes. And, time permitting, or if allowed, I can do that.
Did that video show other children besides your daughter?
Yeah, it depends on, usually I focus on her because I'm doing this to focus on her. What it is the teacher is the one that controls it. So whatever thing that the teacher is showing on the screen is what I capture because I videotaped the screen of the teacher, through her permission because she invited me to, or the parents, not just me, to attend. And as I was reading, no, I don't have that much time again. As I was reading through the GAL report, there are a lot of errors in them, okay? Like the dates obviously shows that this is somebody who didn't take the time to do that. Like the date of my daughter. You can say it's typo, it's not typo. You can also, there is also mother that their marriage was arranged. I told this, in fact, I prepared Exhibit B, Volume 2 of 2, to tell GAL that it was never arranged. We are from Nigeria, we're not from India, and I'm sorry to name a name. But we don't arrange a marriage. The lady's family, they're all very educated. The brother is an attorney. Unfortunately, he died because of kidney this thing. They will never allow something like that to take place. In fact, she begged me, of all and I'm not putting her down, of all the family members, she's the only one that didn't go to college. In fact, she did not graduate from primary school. She told me she did, and then she came here. I tried to put her in school, and she can never pass. I was at UC, and a spouse can go there for a very low price or fee, and she can't take the exam and pass it. So I told her that the marriage was never arranged. And I have documentation to also show that she told me I should bring her to the United States for medical treatment. I paid for her to get surgery because she had a lump on her back, to get the lump, to get it removed in Nigeria. And after that, she said, "Oh, it's still itching me. I want to come to America." Until the American embassy informed me, because I was telling American embassy give her visa to come for treatment, and she was going there and telling them that she's coming for as a fiancé. And then they informed me, and then I said, okay. And then she called me, oh, they told her that's what she has to say. Okay, so, all these things are not, I was not allowed to show evidence that those things took place. And also, GA, again, is very
So
wrong.
you have about 30 seconds of your 12 minutes.
Okay, let me see. And another thing, okay, when that's the fact, I could not get the documents to get the facts from him or from the GAL to cross-examine him during the trial. So the fitness here is, I don't think actually that the GAL is fit for this job, because he obviously took offense to me filing motion that he should be fired. Okay, he's a professional. He shouldn't do that. When I was teaching in college, students appeal my grades all the time. I don't just go and mark them down, and I think that's what he did. His investigation and the write-up, if you read this report, it's so, you can't write something like that, okay? Because there is really is opinion. There is no evidence, and a case is, the other party was cited for contempt of child custody, and he still recommended that she is better to do it. I stay home. And by the way, my son...
Go ahead and wrap up.
Okay, my son, because of the GAL, was hospitalized in UC from August 20 to 27, because with the mother, he goes about stealing from stores and then using drugs, not going to school. So, he could have died. The cost, I just got it, is over $20,000 for 8 days. If he was staying with me, when they were staying with me, he was a student, draw out, because I wanted them to go to Ivy League, okay? I went to good schools here. When I came on government scholarship from Nigeria, went to Wisconsin, Missouri.
You can keep going, or I can reserve you 3 minutes.
Okay, let me reserve the 3 minutes.
Okay, thank you.
Thank you.
Thank you.
Yeah, thank you.
Good morning, and may it please the court. The June 23, 2020 decision is not a final appealable order, and this court lacks jurisdiction to address the issues that Mr. Longbay has discussed. When this post-decree litigation began, there were 2 motions filed, one by the appellant and one by the appellee. The appellant filed for a modification of custody and parenting time. The appellee filed for a modification of parenting time. The hearing that was done on June 23rd, 2020 was a hearing that was addressing the question of change of circumstances for custody. The facts that are related to both motions, the GAL's report, and the beginning of this litigation is all interconnected with the same facts, the same information. Piecemeal appeals are
And the
both.
hearings were held as to all three together?
Can you repeat?
The hearing, there was a hearing as to all three that was held, all three motions were held within the same hearings?
No, Your Honor, they were filed at the same time. The hearing that happened on June 23rd, 2020 was just on a change of circumstances for custody. The trial court, in fact, set the case for additional hearings on the parenting time motions. That was discussed at the hearing on June 23, 2020, as well as was included in the decision that was made that the case needs to be set over for the magistrate for a scheduling conference on the question of parenting time.
You didn't file a motion to dismiss in this case, right?
That is correct.
So the first that you're raising, I mean, obviously, if we don't have jurisdiction, we don't have jurisdiction, but the first you're raising it is on, it was in your brief, right?
Yes.
Okay.
For it to be a final appealable order, all issues related to clearly and finally disposing the dispute between the parties is the standard, and clearly there are some issues that are still remaining to be addressed. The trial court, because all these issues were filed at the same time, the trial court would have had to include language in their order that there was no just reason for delay following Civil Rule 54B, and that language was lacking in this order.
Counsel, what about under 250502B2, which makes an order final and appealable if it affects a substantial right made in a special proceeding? Custody issues are special proceedings.
Yes, Your Honor, they are special proceedings, and an order affecting custody, it would be a substantial right. However, an order that grants custody is not a final appealable order when there's an express determination to defer the issues of child support or parenting time.
And do you have specific case law for that?
Yes, there's a case out of the Fourth Circuit, Rice v. Lewis.
For circuit?
Fourth Circuit, yes. And in that case, the issue was just that there was an order that addressed custody. There was an issue that addressed parenting time. They were separate. It was a very piecemeal process, and the Fourth Circuit found that it was not a final appeal. The custody order was not a final appealable order.
Is that case cited in your brief?
Yes.
Okay.
So I want to go back to the question about the hearings. So there was a motion for change of custody, right?
Yes.
And that's been disposed of.
That is correct.
Okay. What's remaining are each party's motion with regard to parenting time.
Yes.
Okay. And I'm trying to understand, if the custody is disposed of, it seems to me that there isn't going to be any impact on that custody order when the parenting time is addressed.
The issue here, Your Honor, is the question of judicial efficiency and the fact that both the custody and parenting time motions were filed within 10 days of each other in August of 2020. The facts alleged in both are interrelated, and the GAL wrote a report addressing both a custody recommendation and a parenting time recommendation. Because the facts are so intertwined and the requests were made at the same time.
There are also substantial rights that are at stake. So if you ask a parent to wait to appeal on a custodial determination for something like parenting time, or it could be for child support or something of that nature, that isn't going to bleed over and affect anything with the custodial determination, then you're also asking that parent, aren't you asking that parent to sit on their custodial rights, on their substantial rights?
The facts of the two are so intertwined that I would actually argue that the parenting determination could, in a sense, affect the same substantial rights as far as how long the child is with each parent. The request that the appellant specifically made was to have the children for the vast majority of the time as a request for parenting time. And so the two are so interconnected that they shouldn't be treated as piecemeal appeals.
And that's what I'm trying to understand. You say they are so interconnected. Can you share with me how it is that they're so interconnected?
The facts that Mr. Lungbei alleged in his motion as to why he should have custody and why he should have the children for the majority of the time are the same facts, specifically what he found to be lacking in Appleby's abilities to parent. And if he's making the same argument on custody and parenting time and asking for them in the same motion, they should be treated together on appeal.
So, I mean, you're not arguing that if there's any pending motions, post-decree pending motions whatsoever, that all of them have to be resolved before they can be appealed. That's not the argument.
That is not the argument, Your Honor.
So it's just if they're somehow intertwined with each other.
Correct, both factually and specifically in the way that they were asked, the way that he asked for these things was interconnected, and what he was asking for was interconnected.
That seems kind of difficult, though, for somebody that wants to make sure that they're not out of time on appealing certain orders. I mean, I think that out of an abundance of caution, wouldn't you just have to always file a notice of appeal just to make sure, and then let the appellate court decide, I guess, later if the facts are, in fact, so intertwined?
The language that the trial court utilizes in their decisions can be utilized as a marker for anyone considering filing an appeal. In this case specifically, there was significant discussion of what the next steps were in this case and what needed to happen next to resolve the remaining motions. The court made the decisions, I think intentionally, not to include the language of no just reason for delay because there was ongoing litigation regarding parental rights and responsibilities.
And you're saying that the GAL report was done specifically to address all of the pending motions?
That is correct.
Okay.
I would like to address some of Mr. Lungbei's arguments regarding the violation of his due process. The evidence that he provided was not provided to opposing counsel prior to the day before trial.
Well, counsel, okay, I'm looking at the rule here. And what it says, the Rule 20 in the local domestic relations court says a completed CDR list and one set of photocopies of all exhibits pre-marked shall be exchanged between the parties in advance of the evidentiary hearing. At the court's discretion, a more definite date may be established for the exchange of exhibits. That doesn't say it needs to be a week before or a month before. It says in advance of.
Yes, there was no rule broken by Mr. Lungbei by providing 1,000 pages of documents the day before trial. But as in a matter of fairness and within the court's clear discretion, this isn't a question of due process, this is a question of abuse of discretion. It's well within the court's ability to say that we're not going to do a trial by ambush here. There were thousands of pages of documents. There were 30 minutes of video provided the afternoon before trial. In a sense, it was literally impossible to be prepared to address all of those things. And a copy of the actual exhibits were not provided the day of trial. There were no physical copies provided. They were provided in an email the day before. So the trial court didn't have a physical copy. The opposing counsel didn't have a physical copy and could not follow along if they wanted to because there weren't physical exhibits to look at. The only copies of exhibits that were at trial were in the possession of the appellant.
So you couldn't have looked at them electronically?
Theoretically, yes. I do not believe that they were provided electronically to the court. And there were so many of them that the ability to look through them quickly would have been very burdensome. And it really comes down to Mr. Lungbei is a very intelligent individual. He's navigated this court pro se for quite some time now successfully. He understands the concept of cross-examination. He understands the concept of impeachment. He understands the way that this court system works in a way that the choice to provide these documents the day before feels like a matter of fairness.
Well,
And
what I understood him to argue this morning is that there was more than one trial counsel for wife. Is that correct?
that is correct, Your Honor. There was an additional attorney on the case.
And what I understood him to argue is that the same documents had been provided to prior trial counsel for wife.
The prior trial counsel was on pre-decree. The decree was entered in December of 2019. So this counsel has not been on the case for quite some time. I will say the other trial attorney, who is myself, signed on in 2018. So the idea that they were provided to someone pre-decree who's no longer on the case post-decree, but not provided to the other attorney who's been on since 2018, is a little confusing. I think doesn't really hit the heart of the matter, which is this is a post-decree modification motion, and the documents that may have been relevant at the time pre-decree would no longer be relevant regardless. And so if there were additional things that happened post-decree, those were not received until the day before trial. I'd also like to...
And I have one more question. There was no scheduling order in this case that gave a date where discovery had to be exchanged, correct?
That is correct. There was no scheduling conference that addressed the question of exhibits nor discovery. But in a matter of fairness and just as a practical matter, the 403 balance here as far as undue delay and an interest of fairness is clearly within the trial court's discretion to make. And the trial court did give him a full and fair opportunity to present his case. We were scheduled for an hour. The case went on well beyond an hour, about an hour and a half.
Well, I think part of his argument is whether he got a full and fair opportunity to explain.
Yes, and he did.
I'm not talking about during the proceedings. I'm talking about in these pre-proceeding or evidentiary decisions.
Yes, he was provided an opportunity to make an argument, and during the proceedings, the court did allow him to refer to the exhibits, to describe the exhibits, to utilize the exhibits in his presentation of the case without admitting them to evidence. So he was provided a full and fair opportunity to do that, a full and fair opportunity to utilize the entire hour and a half. The entire hearing was his case. And then at the end of the hearing, there was a thank you, Your Honor, and he completed his case. He had multiple witnesses that he called. He did cross-examination, direct examination of those witnesses. He was provided as much of an opportunity as a trial court can provide to make his case. And this was a relatively short period of time. The decree came out in December 2019,
So you have about a
and
minute.
the motions to modify were filed 7 months later. It was a very short period of time and a very short period of evidence to provide. Finally, addressing the question of the guardian ad litem. The guardian ad litem testified and argued that he did provide a significant amount of information to Mr. Alungbe in his report, as well as in the information that he provided. He had all the names of the witnesses. He knew who the people were that the GAL talked to. Mr. Alungbe could have very easily subpoenaed those individuals or reached out to them on his own. He knew who the doctors were. He knew who the teachers were, and he could have easily accessed that information, but did not. His motion...
Counsel, would he have had access to, say, the medical records and the school reports and all of that information outside of the GAL?
He should have. He knew who the doctors were. He knew who the teachers were. He clearly had a relationship with these teachers because he was engaging in the Zoom classroom. The medical records he could have gotten through his access to records as a parent of these children, and or asked the appellee to sign a release, which he did not. The court has broad discretion regarding the regulation of discovery. This motion was filed a week before trial, even if there was some need to produce additional documents, it would have been a great burden on the GAL to do so in such a short period of time. He testified that he had over 114 emails, and it would have taken him approximately 20 hours of work to redact the information before sending it to him. And so it was well within the court's discretion to deny his motion to compel. Appellant filed this appeal too soon because the June 23rd, 2021 decision is not a final appealable order. He submitted his...
Counsel, if you want to wrap up.
Yes.
Okay.
He's submitted his exhibits and requests with information too late. Therefore, we ask the court to dismiss this appeal for lack of jurisdiction. In the alternative, dismiss this appeal for recognizing the court did not abuse its discretion. Thank you.
Thank you.
Thank you. You can probably, if you see me sitting down there, I was going like this. You know, she kept saying that I submitted the exhibit one day before trial. What is he talking about? The question now is, where is the evidence? Can you provide evidence to the court that I submitted my exhibit one day before the trial? She is wrong, and she is lying.
Well, where is the evidence on the record that you provided those? Because the judge said that she was excluding, or he was excluding the evidence because you turned those over to opposing counsel the night before trial.
No.
Where in the record can we go to find that you actually turned the exhibits over earlier?
And actually, like I said, I sent through Dropbox, because as you can see, it wouldn't attach to email, it's too big. So I sent it through Dropbox. And he never expressed any problem with this. And this is what we've been doing. And for the counsel here, prior to her taking over, it was agreed that exhibits can be exchanged electronically. So I have always submitted my exhibits to them electronically. And she also made the statement that exhibits were exchanged. I don't quite understand.
And for clarity, when you said you sent it to Dropbox to prior counsel, which counsel are you referring to?
Oh, okay. Dropbox.
No, counsel. What attorney?
Oh, okay. This attorney here. The GAL and her, because I work with GAL independent of, almost the same, simultaneously, so to say, not at the same time, but whatever thing that I send to GAL that she needs to know, I'll also copy her. And through GAL, if I go to my email, I have records of those, and I can refute what she is saying or hear.
Do you have any response to the argument that you are not appealing from a final appealable order?
No. My response to that is that if the custody thing is not final, what is it? They are not going to do any other thing. In fact, she's arguing that based on the assumption that I will do something.
Well, there were other motions pending, right? That the judge was going to hold a hearing on for the parenting time?
As far as I'm concerned, no, I don't have anything. When that parenting change of this thing ended, that was it for me. I don't have any, as far as I know, I don't have any motion pending. If they said I have, let them tell me or show me. And what will that be? Because the motion is already decided. Currently I have them on weekends. But the problem is that my children are failing. Okay, they are failing. And I'm doing this actually for the benefit of their mother, because if the children are successful, it's her who is going to benefit. I may die. Okay? I don't need my children to do anything for me. I'm financially okay. But I want my children to succeed and help her mother. I brought her here. She went to Cincinnati State and she flunked out of it. She did not graduate from primary school in Nigeria, and she cannot do anything. I'm sorry to say this, but I'm not putting her down. I'm only trying to help her, but she doesn't know this.
Okay, you have 30 seconds to wrap up.
So there's no record of provision of opportunity. I was never given opportunity by the judge to argue to use my exhibit. Never. And I don't see anywhere in the transcript that says that I used my exhibit I pointed to the exhibits because the information, when the judge said, I kept asking, admit into evidence because it has to be admitted into evidence in order for me to use it in court. It was not. So I couldn't use it. So I don't know why she is saying that she's an attorney. There is no weakness. He said that I have weakness. I don't know what weakness is she talking about. I don't have any weakness. And I cannot go and get the people that the GAL interviewed to talk. No, the practice is you talk to the GAL, and the GAL by law supposed to give, or due process, supposed to give me the files and everything, every research that I did.
Okay, sir,
is the GAL.
I'll give you 10 seconds to wrap up.
Okay. And also, I submitted the exhibits online, but the court blocked it. You can go online. You know, there are certain exhibits that is locked. Those are the exhibits that I submitted way ahead of time so that they don't have to come and say this. I don't know why they don't do this.
Thank you for your argument this morning. Thank you.
Yeah.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. And we wish you both a wonderful afternoon. Thank you.
Thank you. I don't know, can I ask a question? No.
That's okay. Before you leave, I'm going to, let me confirm your address to make sure it hasn't changed. Sir, what is your address? Is it Cheviot Road, Sill?
Sir, the judge is asking.
Oh, I'm sorry.
That's okay. Is your address still Cheviot Road?
Chef, yes.
Okay, thank you.
Yeah.
All right, thank you so much.
I'm sorry, I didn't do
That's okay. No worries. If you have any questions on process, you can go to our office and talk to the front desk, okay?
Okay.
All right, thank you.
Thank you for being patient.
You have a good afternoon.
Thank you so much.
Okay, thank you. All right, good morning.
Good morning, Your
All righty, so this is our second and last case, Sharif versus Sharif, case number C210472. Whenever you're ready, Attorney Howard, you can come and... All righty, how are you doing this morning?
I'm well. Good morning, Your Honors.
Good
I'd like
morning.
to reserve 5 minutes,
All
please.
right, whenever you're ready.
I got a notice from you yesterday about a concern about
Finality.
finality, and I'm not quite sure exactly. There's nothing left in the trial court, and I now know part of what probably fueled that. But there is nothing left in the trial court at this case.
I think the question is that there, in the judge's entry on objections, that's the order you're appealing from,
Yes.
correct? The judge says the party shall submit the finalized and signed support agreement. And one of your arguments is that he shouldn't have ordered, this was not a final.
Correct.
There was still negotiations, and my understanding is your client did not sign that.
Correct.
So is there not a new child support order in place?
No, there is nothing. The old order that was in place from 2017 is the order that's currently in effect. There is no new order. The court did not put it of record, even though the court said it was going to. At the bottom of the page of that first agreed entry, he said the court adopts the agreed entry detailing the support agreement attached to plaintiff's objection. He didn't do anything with it. He didn't adopt it.
So in effect, would you say that it's been denied then, the motion?
My motion to modify support? No, it's in whatever. It's really hard to tell you what he did because he said he adopted it. When I asked if he was going to, not him, but his clerk, if they were going to put it of record, the answer was no, not until the party signed it. And I said, well, if my party signs it, then he's waived his appeal, so he's not going to sign it. We don't agree with those terms. That is not of record at this point.
So isn't his motion still outstanding then?
No, the motion's, he's ruled on the motion. He said, here's your new child support amount. That's what we're appealing because he issued an order without an agreement. There was no agreement.
So if we find that there is no agreement,
We're
then
asking-
that is not final, that the support issue is still outstanding.
Correct, Your Honor. So we're asking that the court remand that matter back to the trial court for hearing because there has never been a hearing.
Okay, but let me continue.
Sure.
So if that's the case, and if we remand the support issue, would the rest of it be final?
No, to final, yes. To the very point you were talking about before, there actually is case law that says that, and there's one from the 4th District, not Circuit District. I'm going to probably mispronounce this. It's Koroshazi, Koroshazi, v. Koroshazi, 110 Ohio Appellate 3rd, 637, 1996 case.
Can you repeat that site, please? I'm sorry.
Sure. 110 Ohio Appellate 3rd, 637. And that case says that in the absence of an immediate appeal, one of the parties would be foreclosed from an appropriate relief in the future. So these other issues have all been decided. They're separate issues. And then there's another case, O'Neill. Actually, that's the one that's 4th District. Koroshazi isn't. This is O'Neill versus Crawford. O'Neill versus Crawford, 2004 WL 259001. The fact of the father's pending motion for parenting rights did not affect the finality of an order establishing paternity and ordering support. And then there's another one, Smith versus Smith, a 2009 WL 2457798 out of the 5th District that says a court's order dismissing the father's motion to recalculate child support was a final appealable order because he can't reassert the refiled case and have the same effective date. So the other matters are completely separate. They were filed at separate times. They're all about parenting and attorney fees. They're really not related to the issue of support at all.
So if your client is refusing to sign this order, saying that he doesn't agree to it,
Right.
then you're going to have to litigate the child support issue.
Unless this court affirms it, and our position is that under both case law, our local rule, you can't move forward on this. You can't move forward without having an agreement that has been affirmed by the parties.
Right.
The
So, I mean, the
parties-
judge can't force your client to sign
Exactly,
that.
and that's where we are. Because my client has never agreed to it. There's never been any consent on the record. It's not been read into the record. The cases cited by counsel are misleading from the standpoint that they do not address the issue at hand. So the two that are cited, LEH Properties versus Pheasant Run and Arugula, I'm saying that wrong, Arugula versus Bonzel out of the 10th District. In both of those, there was either read into the record, or a writing signed by the parties where the parties specifically agreed. We have nothing. There was never a request, there was never a question asked. It was never before the court to say, do these parties agree to this In fact, the fact that we
Is there a
had,
motion that you could have filed rather than an appeal on that issue?
he ruled, I was stuck. I had nowhere to go.
But I
He
think
filed an objection on it.
the judge was under the,
They
I
filed
think
an
the
objection.
judge was under the impression that the parties had an agreement to child support, and the judge didn't need to make that decision. So he says in the order, hey, there's an agreement, everybody sign. I'm just thinking that if your client refused to sign, there should have been some notification to the judge, like, hey, wait a second, there is no
We
agreement.
didn't have that option because that matter didn't come before at that hearing. That hearing was on the other issues.
Put a motion to reconsider or
You
something.
can't, there's no such motion in court. It's a motion to
So
reconsider.
there was no way to make the judge aware that your client refused to sign this, that this wasn't an agreement.
So if you looked at the documents that counsel for plaintiff attached, she attached two different versions of a draft agreed entry and an email between us where I said, we'll let the court decide on the issue of child support. It was very clear. And it was attached to the objections. So it's very clear that there wasn't an agreement. I don't believe the judge, I don't know what the judge thought. I frankly don't know. What I do know is that if that's what he thought, it was an error. Because there is, and I've been in front of court so many times when we've reached an agreement and the court bends over backwards to say, you must either have a signed agreement or read it into the record.
Let me make sure I understand, okay?
Sure.
Are you appealing the judge's determination that there was an agreement?
Yes.
Okay. So isn't that basically a factual determination to a certain extent?
Both.
Okay.
Certainly there's fact there, yes.
Okay.
And there's no evidence of there's no factual evidence of an agreement. There's nothing in writing signed by the parties. There's nothing on the records that the
It
parties
just seems like an
acknowledged.
awkward procedural posture.
It's very awkward. And Judge, I wish we had somewhere to go with it, but I didn't have anywhere to go because it came up on objections. And the judge, I tried to have oral argument. That was denied. I submitted a memorandum in opposition, and counsel submitted her amended objections. But if you read the judge's entry, he says this came before him on plaintiff's objections. He did not mention my filing on the 1st of September. He didn't mention hers on the 2nd. It's very clear to me those were never considered. And if you look at the timing, and I've addressed this in my reply, if you look at the timing, it's very unlikely that he ever saw any of it, and that even though he told us he was going to consider it at 9 o'clock on September 3rd, it's quite likely that that had been decided long before because he couldn't have gotten it through the process in the time that to have it entered on the 3rd. So that's not likely.
Ms. Howard, I want to clarify something.
Sure.
Okay, so on page 3 of the transcript, the judge says you've reached an agreement. Okay, one was the child support, but it sounds like blah, 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 you've reached an agreement. Is that correct? Ms. Keller says correct, and you say yes, Your Honor. So let me just understand. So if I'm understanding your argument and your reply brief properly, you had reached an agreement, but it wasn't the one that was submitted to the court?
We thought we had reached an agreement.
Okay.
Okay. As it turns out, we hadn't, but we
Okay.
thought we had.
Okay, so it hadn't been finalized by that point?
Had not.
So there were certain terms that were agreed to, but the final terms were
We never
still
got-
left outstanding?
We thought we had an agreement. We ended up not having an agreement. So the magistrate didn't.
Was that communicated to the court? Because clearly you communicated you had an agreement to the court.
We thought we had one. She said, so it appears, or some agreement, and we said we thought we did.
Okay.
We moved on. We didn't address that. So this hearing before the magistrate addressed the other issues. It did not address the issue of child support. We addressed parenting time, we addressed attorney fees. We did not address the issue of child support.
But the magistrate went ahead and addressed it anyway.
Exactly.
Okay.
And then I didn't know what the judge was going to do with it, and the judge did what he did, which.
But your client didn't object to the child support because it was in his favor, right?
Right.
Okay.
Right, and we didn't know what the judge would do. We didn't know if he'd say, well, it's not been, there's no evidence in the record, send it back, which is what he should have done, but he didn't do that. Instead, he made an assumption and didn't have the people come in and say, hey, do you have an agreement? And so he put us in the position of saying, you just adopted an agreement that nobody has acknowledged. We don't agree
And
with it.
ultimately refused to sign.
My client has,
Right,
sure.
yeah.
As to the other issues, Your Honor, on the Monday parenting time, In 2016-17, we had a hearing. My client got Monday overnights in exchange for losing his Thursday time to have consistency for the children and fewer transitions. So now the judge says his goal is to have consistency, fewer transitions, and increase quality time. He did exactly the opposite. Counsel in her brief says, oh, but there are fewer Monday transitions. Of course there are. Now that many are now on Tuesday. So it didn't reduce the number of transitions, it just moved them up from Monday to Tuesday. And now my client, who fought hard to get that time that the court gave him several years ago, they just took it back. He already had less than 50% time with the kids. Now he has far less because instead of him having the children all day Monday and then Monday overnight, he now loses them a whole 24 hours Monday to Tuesday morning. He doesn't have them at all, even though he can be with them all day. The judge, again, erroneously says he cited 2 pages in the transcript that were nothing but precatory remarks before we even got to the hearing.
Counsel, I'll give you 30 seconds to wrap up.
If you read what my client said, pages 52, 54, it's very clear. He said, I can be with these children all day on Mondays. I don't lose them. And then as to attorney fees, there is no evidence presented other than mom identifying Exhibit 18, nothing.
Was there a hearing?
Yeah, it was part of the hearing. They just didn't put on any evidence. She testified to it. She identified the exhibit. Counsel did not testify, didn't meet the Ruley case law standards, didn't meet our mandatory Rule 17.1, didn't meet the Swanson criteria, none of it. And the judge bases his decision on something that happened in 2017 and in 2014, which is to say, I guess once you've asked to modify support or parenting time, you can never come back and ask to modify parenting time. And this was a different request than ever before. We had never asked to have Monday parenting time following his weekends during the days the children are in school.
Thank you.
Thank you.
Good morning, Your Honor.
Good morning. How are you?
Should I just start?
Whenever you're ready.
Okay. As to the issue of whether there's an agreement, the key here, Your Honor, is that there is Your Honors, there is no dispute at all about the terms. If you look at any case on a dispute about an agreement, it's like, we think the agreement was this, they think the agreement was that, so there is...
Can you address whether it's a final appealable order, first of all?
I do believe that it is a final appealable order because,
So it's appealing the judge's determination that there is an agreement and ordering the parties to sign the agreement, which ultimately was not signed nor entered.
Yes, I don't know why the judge didn't say, well, since you're not going to sign it, I'm just going to adopt it. I don't know about that, but there's nothing else pending. For practical purposes, we're all here, we've done it. I don't think any of us want to come around and do it again just because a piece of paper gets filed. I consider it a final appealable order.
But you're saying that despite the fact that he refused to ultimately sign this agreement, there is an agreement?
Absolutely. And that, again, that's getting to the point that I was talking about. There is no dispute on the terms, and it was clearly in writing, and it was before the court. This is the agreed entry that went back and forth. The only dispute at all was that Ms. Howard did not understand how the relatively new cash medical works, which is maybe, 5 or so years ago, they added a new thing to the child support worksheet that if health insurance for the children is dropped, then the cash medical goes in place and whoever is getting the child support gets the cash medical. Ms. Howard the worksheets now automatically generate that number, and the only question we had whatsoever on child support was whether or not that payment immediately goes to mother. Ms. Howard, before the record turned on, Ms. Howard asked the magistrate that. The magistrate said, no, that doesn't go to mother unless health insurance is not in place. And then both attorneys said, okay, that was all we needed to know. The entry will be submitted. And then it goes on the record. Both concur that there is an agreement. There is an agreement. The amount of the child support to be paid was in writing. The only disputes whatsoever, if you look at the redlining that was going back and forth between the attorneys by the time of the objection hearing, was about something about a passport, which is not in front of you guys.
Yeah, but doesn't that mean there's not an agreement then? I mean,
No, because
whether it's something small, the point is that it wasn't signed. It wasn't agreed to by by father.
No, because this case is in different chunks of different items. Passports were never before the court. That was just a separate thing we agreed. There was never a motion on it. It was just a separate heading that was put in that agreed entry.
But it's still part of the whole entry. I mean, a contract is a contract, and unless the parties agree to all terms, then it's not a contract.
Yes, and by the time, before the objections were to go on, my client agreed to Ms. Howard's language on the passport, and that's exactly what was submitted to the court. It says, okay, we're putting in the language that you wanted about the passports, so there's no further disagreement at all. Please sign the entry. And
But if he refused, then what the judge probably, and this is what Ms. Howard is talking about, the judge, should have then just said, okay, well, I'm going to decide the issue. Right? It wouldn't be an agreed entry. It would be the judge making a decision.
I don't agree. As Ms. Howard said, we never tried the issue of child support, obviously because we agreed to it. So there's a question of what kind of hearing there would be. I thought there was a little confusion about that, maybe not. But if this remands back, I don't believe the hearing that it goes for would be a hearing on child support. The hearing would be, is there an agreement? And that's when you would get into the emails back and forth and what people said, and there'd actually be a hearing on whether or not there's an agreement, not a hearing on what the child support should be. And that's exactly what all the case law that Ms. Howard cited said. The hearing is on whether there was an agreement or not an agreement. And Ms. Howard, that's her argument, basically, is that she should have had a hearing on whether there was an agreement. Well, that hearing was the objection hearing. And Ms. Howard very easily could have asked for an oral hearing on objections. That is totally allowed in that court. You may request an oral hearing, and you'd have something very similar to this. The judge will automatically set it for just a hearing on the briefs. So one side briefs, the other side briefs. And that's what the court set for, and that is what Ms. Howard consented to. She did not request an oral hearing where she could have raised all of this stuff saying there wasn't an agreement. She filed a written brief. She's had her say on whether or not there was an agreement. She had her say in the written brief. And there is no way the judge didn't look at her response. I mean, just because he sets it to be decided that day, he tells everybody, okay, all of your paperwork has to be filed by this time, and he's ready to go. So I had filed my amended brief, and it's amended, of course, because I had to wait for the transcripts. That's the whole point. If the transcript had not been ordered, my whole objection would have been kicked out. So the transcripts take 6 weeks or so to come in, and then I went through and did transcript cites and cited it all, and that was the amendment, was with the transcript cites primarily. So my amended brief was filed. Ms. Howard filed her brief. We both filed them before the deadline given to us by the court. And he made his decision that day. That's the whole point. He's telling us, that's the day I'm going to make your decision, my decision, so make sure you have everything in by that day. And so she's had her say, and nowhere in any of this has she ever said there was a dispute over the terms. She has never said, look, it's right there in black and white, this is the child support amount that we've agreed to, that I have in writing, and Ms. Howard's never said, no, we didn't agree to that amount, we agreed to another amount. She's never said it because it's not true. There was an agreement.
Well, the magistrate, for whatever reason, decided to decide child support, and I guess made father pay less. So now they're happy with that.
Exactly.
Right.
That's exactly what happened, Your Honor. He saw, oh, wait, this order's less than I agreed to, so I like this. So that's exactly what Ms. Howard just said it. Her response to me when I gave her the agreement that there were absolutely no issues on because we had conceded to her that final issue on the passport that hadn't been in front of the court, she just said, oh, on child support, we'll just wait and see what the court does. And the reason it was lower is because Dr. Sharif is a surgeon, and he stopped working as a surgeon and started working for an insurance company.
For significantly less.
Yes, for significantly less money, and we had an argument that he was underemployed. So obviously, since we settled that, we didn't proceed with our argument that he was underemployed, so therefore, of course, the child support amount's going to be less, and he is just trying to capitalize on that. Unless you have other questions on that, I'll move on to it.
Can you talk about the
Yes.
attorney fees?
Oh, absolutely. So for attorney fees, there are multiple cases that say courts have discretion. So what is in the record there is my client testified to the attorney fee bill. That is an exhibit that had been provided. So let me back up. We filed a motion for attorney fees, so they were on notice that we were asking for attorney fees. I was listed as a witness who was going to testify about attorney fees.
Did you?
No, because we ran out of time.
Oh, okay.
My client, we were given so many hours and there was only so much you could put in. My client testified to the fee bill. And we put in a lot of, that's why the tax returns were in there. That's why the magistrate made the mistake of making the child support decision, because the tax returns were there. The only reason that the tax returns were there were to show what people's incomes were for the attorney fee issue.
Did you submit an affidavit on the reasonableness of the fees?
No, just the attorney fee bill itself, not an affidavit on it.
Isn't that kind of required?
No, and that's what I'm going to address. Multiple cases say that courts have discretion to follow or not file their own local rules. I cited multiple cases that say that in my brief.
Isn't that only if it says may rather than shall?
No, the case that Ms. Howard cited for that was a statute. Yes, if a statute says may versus shall, then yes, you have to follow it. But
doesn't it make sense that if the rules say shall, then
No.
the court, explain to me why not?
Because they don't have to follow their own local rules. Local rules are discretionary to them. There's a lot of case law that says you don't have to follow it. That if a statute says shall, it has to be followed, because that was done by the legislature, not the court. But case after case after case says it is well settled that courts do not have to follow their own local rules.
But the statute talks about reasonableness of the fees, right? I mean,
the statute does not say you have to put any testimony in.
Well,
And here,
no, but it does say that the fees have to be reasonable.
Yes, and I'll address that now. Multiple cases also say that the trial court is able to evaluate the work performed by an attorney in domestic relations cases by looking at the record and using its own knowledge. I have practiced in front of that court for 27 years. They saw the hearing. They have heard my testimony about my qualifications dozens and dozens of times. It's absolutely nothing new to that court. I mean, it would just be me zooming through a pre-prepared statement that judge has heard over and over and over again. The important thing is their personal knowledge of me practicing there, of other attorneys practicing there, of what is reasonable. Because obviously if I testified, I would have said, yeah, my fees are reasonable. Now, Ms. Howard said that her client didn't have a chance to cross-examine. Well, absolutely he did. We were given a certain amount. Yeah, I was listed as a witness.
She could have called you.
Yeah, she could have called me. The bill was there. But again, there was nothing to criticize in the bill. I have been practicing for 27 years. I have done nothing but domestic relations work. I have 2 Ivy League degrees. I'm a partner at a large law firm. I'm on the admission committee of the American Academy of Matrimonial Lawyers. I mean, there's nothing you can criticize about my abilities and my qualifications. And they certainly had so she didn't waste any of her limited time doing that. It was her choice. She had the option to do that. She could have called me. The exhibit bill was in evidence. It was obvious that we were going forward on it. The tax returns were in evidence for the only reason of attorney fees. So both sides decided to proceed with what they thought was the most relevant evidence on limited time. And as to the parenting time, we are talking about an abuse of discretion standard. And father wanted an order that said the kids would have been with him Saturday, Sunday, Monday, Tuesday on the particular weekends in question. His testimony said that he could be with the children for part of Mondays because, and remember, this is his brand new job, and the record shows he's had multiple jobs. So for this one particular job that he happened to have, during the day we were in court, no guarantee how long that job was going to last, he said he could do his work, he testified, he could do his work 24 hours ahead of time. So that, and his testimony actually says, and I'm pretty sure it's cited, the transcript's cited exactly in my brief, that he could do half of his Monday work on Sunday and the other half Monday morning. So considering he has the kids straight through, Sunday, Monday, Tuesday, you're not gaining any time there. For him to free up the Monday so he can say, I'm free too, he's got to work when he has the kids on Sunday. Now, the whole point is Mother has always had, during this whole process, Mother has not worked on Monday. She's always had the full time to be with the kids on Monday. Didn't have, I believe Father also testified he had to be available for calls and things like that.
Wasn't his testimony, though, that he was planning to do his work when the kids were asleep?
Yeah, I don't believe you can do a half a day's work when the kids are asleep. I don't find that credible. What would work best for the kids is he could be with them all day Sunday and not spending half of the day on Sunday working so that he could have Monday free. Then on Monday, he could do Monday's work and he could do half a day on Tuesday. So then when he had the kids on Tuesday, he could spend the time with them on Tuesday. The only reason he's focusing on moving things around so he could be with the kids more on Monday and not mentioning Tuesday at all is because he's trying to take the time away from my client who does not work at all. I mean, the sensible thing is him be with the kids on Sunday, Mom be with the kids all day on Monday, and then he can free up his time on Tuesday to be with the kids. So he ends up with pretty much the same amount of time with the kids. And this is an abuse of discretion standard, and that is all that, I mean, that alone, we don't have to talk about anything else. That alone is enough to pass an abuse of discretion standard.
Did he end up with less time, though? ultimately?
Overall, probably, okay. I think, a few hours less.
A few hours?
I have not done the calculation. Some amount less. It's not a day, but some amount. And keep in mind, Your Honor, we are only talking the days that the children aren't in school. So I haven't counted them out. Maybe 6 days a year we're talking about. This is not every single Monday. This is only...
It was like summer, right? The summer vacation.
It's only the days when the kids aren't in school.
Summer vacation.
Yeah. So his time in the summer that neither parent has requested a vacation. So and probably maybe some Monday holidays, I don't know, but we're not talking about a lot of time. Can you let me know how much time I have left, Your Honor? Am I about out? Or
You got 30 seconds.
Then I will close unless there's a final question. Thank you, Your Honors.
Thank you.
Thank you.
Let me just quickly address these various points. With respect to parenting time, it's a lot more than just a couple hours. It's a full day every time he loses it, and it's every day the children are off on Monday. So it's during the school year too. So it's a lot of days.
Well, ultimately, it is an abuse of discretion.
It is, Your Honor.
How would you address that?
And so if you look at the judge's entry again, it's pretty clear from the citation he made, he didn't read the record. He didn't read the memorandum I submitted because it's not reflected in the entry he wrote. The only thing he considered on the entry, he said, was the originally filed objections. So he didn't consider what I wrote. He didn't consider the supplemental, amended, whatever they were, objections. And he clearly hadn't read the record. If he'd read the record, he would have seen my client said very clearly, I am available on Mondays. I can do whatever the kids want to do. I can work around them because that's...
But it sounds like your argument is if he had read the record, then it would have gone my way.
If he had read the record, he wouldn't have made the finding that by doing what he did, which is flip what the magistrate did, that it would give the kids less transitions and more quality time with both parents. There's no way by doing what he did that he accomplished either of those. He did not. He accomplished neither of them. He took away significant quality time with my client, with the kids. Ms. Sharif is already off all day on Thursday. She's already got a full day with the kids. This was a day he could have off and be with the kids because he can work his schedule around it. So to accomplish the two things the judge said he wanted to accomplish, he did just the opposite. That's the abuse of discretion, okay? With respect to the issue on attorney fees, the cases, and I dealt with this in my reply brief, the cases counsel cites are cases where the court, the decision maker, is the trier of fact, unlike here. In this case, the magistrate was the trier of fact. She said no attorney fees. As the case, if you read how the case came out, I put my case on first. And then at the end of their case, the only thing that happened was there was an appeal, there was an identification of Exhibit 18. There was nothing else. It was one question. So I wasn't about to ask Ms. Keller questions about something that had never been put before the court, why would I do that? I mean, she hadn't put it before the court.
So, okay, so because you're saying, obviously, it's her burden
Sure it is.
to prove reasonableness, so you're not going to call her as if, you know,
Right.
on cross.
Why would I do that?
Right.
And if you look at the Swanson case, which this court in Zerby has clearly affirmed, there are factors that have to be addressed. And if you look at her bill, a lot of that bill went to things that happened in mediation, which was not before the court. So if she's asking for attorney fees, she didn't articulate what portion she's asking for, what related to what. What the judge relied on is something that happened back in 2014 and 2017. My client never got the ability to testify. He lost his job. The reason we requested a modification of support was because he lost his job as a surgeon. They had a cutback. When things got cut back, he was the junior guy and he lost his job. Then he couldn't get one, and when you can't get a job as a surgeon after a year, nobody will hire you because you haven't been in the surgery. He testified to this. He testified to this. Absolutely.
We've got the record.
So
This is not a trial court.
he's got a job, the best job he could get, which was significantly less. But it wasn't because he was trying to reduce child support. But the reality is it did give him more time to be with the kids, as it turned out.
You have
So-
a minute left.
Thank you. So with respect to attorney fees, there's a clear abuse of discretion here. There was no testimony. She didn't meet the criteria that have to be met. Rule 17.1 is shall. You shall do this or you won't get fees. So I believe that there's clear abuse of discretion. With respect to the child support draft entries, my client has never agreed with those terms. Counsel were talking back and forth. For Ms. Keller to say that the hearing now wasn't whether there was an agreement, no, that's not my issue. The hearing is that there's never been any agreement on the amount of support.
So what she was saying is if we would somehow agree with you and it would go back, then there would be a hearing on whether there was an agreement.
No.
You're saying, what would happen if it were?
There should be a hearing on our motion to modify support. We filed a motion to modify support that's never been heard.
It's still pending.
It's still pending.
Okay.
It never got heard. And so, and it also.
So you're not saying what the judge did here was effectively a denial of your motion? You're
It was
saying
a
your motion
complete
was
error.
never ruled on?
But not a denial.
Okay.
I don't know that he denied it. It's a lesser amount than what is currently of record, but it's wrong because it was never agreed to. You have to have agreement. You have to have agreement. And to say I didn't object, I tried to have an oral hearing. I was denied the oral hearing. When we
And is
requested.
that on the record?
It's not because the court doesn't do it that way. It wasn't my objection. It was their objection. So when I called to find out from Darren whether there was going to be an oral hearing, he said, no, the judge is taking it under advisement at 9 o'clock on September 3rd. And so we had things submitted, but clearly he didn't reflect that in his entry that he ever considered them. So
Thank you for your argument this morning.
thank you very much. Appreciate your time.
Thank you both for your arguments this morning. We will take the matter under submission and issue you a timely decision. Okay, we wish everyone a wonderful afternoon. Thank you. That concludes.